Welcome everyone to our webinar, Family Dispute Resolution, the New Laws. I'm Karen Wazelenka, Executive Director of the Saskatchewan Association of Social Workers, and we're really pleased to host this webinar today with SASW. I'd like to begin by letting you know that I am here in Regina at the SASW office, which is situated on Treaty 4 territory. We are on the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Nakota, Lakota, and the homeland of the Métis. Ruth Ann and Charmaine are in Saskatchewan, located on Treaty 6 territory and homeland of the Métis. We respect and honor the treaties that were made on all territories. We acknowledge the harms and injustice of the past and present, and we're committed to moving forward in the spirit of reconciliation and collaboration. So a couple of housekeeping notes before we get started. Everything that you need can be found in the blue and white icons that are at the bottom of your screen. Your screen is completely customizable, so take a minute and rearrange it to what you need. Certificates will be accessed at the end of the presentation, so watch for your email, or you can download your certificate directly. The handout icon is where you will find the slide presentation. So our webinar today is about 1 hour, and we are going to have some time at the end for questions. So please, as we go through the presentation, type your questions into the Q&A function, and we will get to as many as we can at the end. And with that, I am going to turn things over to Ruth Ann Thomas, SASW Council Member, who's on the phone and will introduce our presenter today.
Thank you for that, Karen. Hi, everybody. I am, as Karen said, an SASW Council Member. I'm also a social worker who is still practicing. And in my effort to practice and learn new skills, I decided that this summer I would take a couple of courses. And it was in taking those couple of courses that I had the opportunity to meet Charmaine. Charmaine is, well, the only word I can really think to describe her is amazing. But you probably want to know a little bit more than that. Charmaine is a lawyer who works doing collaborative law. Charmaine understands the emotions that people go through as they're dealing with family law situations, divorce, separation, custody, all those sorts of tough issues that affect all of the families that we work with. Charmaine is one of the few people in the province of Saskatchewan who is very, very up to date on the new changing laws and has met all of the qualifications to be involved in assisting families with that. Charmaine has generously donated her time to help us as social workers to understand the new laws that are coming in, that are already in place in some of the province. And it is an honor for me to say, Charmaine, please take the floor and share some of your knowledge with us.
Well, thank you very much, Ruth Ann. Very generous introduction, and I'm just absolutely thrilled to be able to be here today with all of you. The only way it could be better is if we had a forum where we could all be together in person, because it's very nice to see each other's faces and get to know you in that fashion. However, I do hope that those of you who are on the call today know that I'm only ever an email or phone call away if you would like to connect to discuss the things that we're going to talk about today further, or if something comes up in your practice that you'd like to just bounce off of a family collaboratively trained lawyer and mediator. And so I too would like to acknowledge presenting to you here today from Saskatchewan, Treaty 6 territory and homeland of the Métis, and to pay my respects as an uninvited visitor. My pronouns are she, her, and I can tell you just a little brief background about myself and what brings me here to you today to talk about the family dispute resolution process as a now term of art embedded in the changes that have been made to the Divorce Act that hopefully will be enacted very soon, and particularly here in Saskatchewan, how that's being embraced. And so, why is this important? Well, first of all, I'll just tell you personally for myself, I have 11 children. They range in age from my youngest is 8 now, and my oldest will be 30 coming up here right away. And I know some of the questions that you might have, so I'll just answer them before you start populating the Q&A box. That yes, they're all my biological children. They are all individual births. We don't have any twins or triplets or anything like that. And we do know what's causing it. So we figured that out. And so the youngest being 8, we now have 4 grandchildren as well. And needless to say, of course, I love children and I'm passionate about families. And as a family lawyer, I've been practicing for almost 16 years now. And I've seen, so many families go through this transition of living together in one household and needing to figure out how they co-parent and how they manage their finances, divide up their property when they're at that point in their life journey where they need to live separate and apart. And there are all sorts of circumstances that play into that. But at the end of the day, we're still talking about family. And it's the family system that is just in a new format. And they need to figure out how to make that work. So the adversarial, the more conventional sort of litigation process where parents go before a third-party decision maker to say, hey, this is, all of the terrible things about my co-parent that I want you to take into consideration in making a ruling that's in my favor. I don't know who it was that ever thought that that was a proper environment for healthy families in their transitions. But we know, and the research, social science research, as you all know, supports that this is just not conducive to the healthy development of children. And if we look at statistics here, we know that we have a large number of separated or divorced Canadians, and our statistics still stay, in that 50% range in terms of long-term relationships that break down. And these Canadians that are living in separate and apart households as adults, they are sharing children, and there's approximately 1.2 million of these little people in our country that are 18 years or younger. And so the individuals who are separated, they need to have some sort of functional relationship going forward in order to effectively parent their children. And so there is a need for something different than that adversarial process that pits those individuals against each other and then expects them to just go out through those court doors and be able to then work well together in parenting their children and modeling a healthy relationship. So there is a need for these other processes. And of course, there's a really important piece here is that we need to have trained practitioners to deliver these services. So let's talk about what exactly a family dispute resolution process is. And I'd just like to make a couple of comments. One is I did put into your content folder here on this platform the slide deck. So you have that available to you to save onto your computer or print it off if you would like to follow along or for future reference after today's webinar. I've also uploaded from the government the Divorce Act changes explained. And of course, course, today we are just going to be focusing on the family dispute resolution process, but as many of you would know, there have been a ton of other very interesting changes made around terminology, around notice provisions for mobility applications, and with a greater and much needed emphasis on intimate partner violence and domestic abuse. So you do have those available to you, that information here, and I imagine as we go along, you might have some questions, and do please put your questions into that Q&A box. We will just kind of barrel through all of the material I'd like to share with you, and then we're going to set aside some time at the end of our hour to go through some of those questions, and rather than take them as we go along. So please don't hesitate as they come to your mind, write them down. All right, now in section 7.3 of the Divorce Act, this is a new section, and it says, to the extent that it is appropriate to do so, the parties to a proceeding shall try to resolve the matters. Now, I've emphasized the word shall because shall in our legal world, it has a very defined meaning, and that is that you don't have an option. This isn't just a suggestion. This isn't a, hey, it would be good for you to try something first. It's actually a requirement. So in other words, parties that are proceeding under the Divorce Act, and of course this is going to apply only to married families, but provincially as far as the similar types of requirements for people in common law relationships to have their matters sorted out, the provincial legislation would be applicable, and there is a consistency from the Federal Divorce Act legislation and provincial legislation. So really this expectation, this requirement that the parents would have to work through a family dispute resolution process other than a court proceeding. So don't lose sight of the fact that even though I'm very upfront about seeing that I believe that family law is like a square peg trying to be put into a round hole of the litigation process. It just simply does not fit. It does not work. It is nonetheless one of the dispute resolution processes that exist out there, right? If you can't figure things out, you can go to court. It is a process. However, this new term of art, family dispute resolution process, it has a specific definition in the Divorce Act that we're going to look at. But let's ask ourselves, well, what are the reasons for these changes? Well, the people that studied and the committee that put their mind to what changes needed to be done, one of the things that they thought of is the fact typically these other kinds of processes tend to move along a little quicker and they're less expensive. There are always the outliers, of course. So, let's make sure that we acknowledge that. But in general, I can tell you that if I was, and I don't do any litigation work anymore. However, if I was to run a litigation family file from start to finish, I do the high conflict court ordered mediation out of Saskatchewan, and it's not uncommon for me to be assigned a file where the family has literally been in the adversarial litigation process for 10 years or longer, and they have each spent often in excess of $100,000. In one instance, there was a file that they had clocked a $200,000 bill each. And so we're thinking that even though there are going to be some dispute resolution processes that maybe take a little longer and are a little more expensive, it's going to be very, very difficult for them to ever actually match up with some of those extreme cases in the litigation world. Now, often children will benefit from seeing their parents work together. I would go so far as to even revise that to say children will always benefit from seeing their parents work together if indeed they're working together from a place of healthy dialogue and effective communication skills. These dispute resolution processes will usually aim to try to keep the parents focused on the best interests of their children. This is much less about the rights of each parent and more about what is going to be best for the children? What in fact are the obligations that the parents have to the children, rather than make this a tug of war where the child or the children is in the middle of it, and that tug of war being around which parent has the greater right to something. Let's just take that language completely off the table. Instead, think about what is going to be best for the children and what are our obligations as the adults who have been entrusted with the care of these children. A DR process, so that's the short form for dispute resolution process, tends to also improve communication skills that these divorcing spouses, these parents, are actually going to need for years. Now, those of you who are on the call that have children that are adult children, as I do, will know that it is a fallacy that parenting ends at age 18. And in fact, if there's anything I've discovered in my years of parenting, is that they've written way too many books about how to parent the baby and the toddler, and there's a real lack of information about there on how you manage parenting an adult child. So any of you aspiring writers out there, I think that is a market. It has been one of the most difficult things for me to figure out. And so when people separate, they have this very naive notion that, oh, this has not been working, so if I can just separate, or if I can have this new legal identity as being divorced, well, then everything's going to be different and it'll be easier and it will be better. Well, in fact, you're actually taking that foundation of difficulty and you are compounding it by adding the stressors that are part of trying to figure out how to manage two households and coordinate schedules, and parenting philosophies that you might have always recognized were different, now trying to coordinate those in a respectful way between different households. Then add new partners, new adult partners into that, and new additional siblings, so you have a blended family. And so the communication skills that you need as co-parents are tremendous, and you don't magically get those in a gift-wrapped bag when you get your divorce certificate. In fact, if you go through the litigation process, nobody's giving you any kind of guidance or support in how to manage what that final outcome is and how to implement it in moving forward. And so you can see that there's good reason, good rationale for these changes, and we're really looking for those, happy, healthy, excited children in the end result. Now, something that's embedded in this legislation that I hope as social workers you will find very interesting is that at Section 7.7 sub 2 of the Divorce Act, legal advisors, so that means the lawyers that people consult, they must, and again, this is a requirement under our code of conduct and enforced here in the legislation, we must encourage clients to try a family dispute resolution process unless it's inappropriate, and we will talk about that momentarily. They must inform of the family justice services that can help to resolve matters. And they must inform the clients about the client's duties under the Act. Now, isn't that interesting? So what are those duties? Well, it's that they shall participate in a family dispute resolution process. And so a legal advisor must actually not only provide information to their clients about the relevant laws with respect to the division of property and support and parenting, but must also explain what the law is in terms of how it pertains to their process and how they conduct themselves in that process. Now, here's the caution, and it's a caution that I'm sure is on everyone's mind, and that is to say, well, we know that dispute resolution processes are not always going to be appropriate. Occasionally, you're going to have instances of family violence, and if I could revise what I just said, I would actually say in my experience, and probably in yours, that family violence somewhere on that spectrum of intimate partner violence is present in so many families families. I would say it's more common than it is an anomaly, and yet we just haven't historically really talked about it in an honest, transparent way. And I do believe that discourse is becoming more common. I think that these changes to the Divorce Act that explicitly acknowledge the impact of exposure to conflict and domestic violence on children, it furthers that conversation. So we have to screen to say, all right, well, what is going to be appropriate for this family? What type of family violence is present? If there's a significant power imbalance, we have to put our mind to that, to say, are we going to be taking somebody who's going to be vulnerable and putting them into a process without proper attention to what they might need for safety. And processes can be designed to mitigate the risks and support safety planning for vulnerable family members and spouses, parents, and keeping in mind litigation isn't always appropriate either. So what kind of protections are built inherently in our court process to address where there is the presence of intimate partner violence or addictions or mental health issues or even power imbalance? I would go so far as to suggest that the litigation process will often compound that power imbalance. And you maybe have had your own experiences where one parent has seemingly unlimited resources of some sort to just continually bring court applications or drag the process out or make false allegations about something and be able to just continue to drive that process to an outcome that they want. And it can be very difficult to find a way to engage in that adversarial system when you have less resource, less power, less voice. And so some of the recent research in the use of these other processes have indicated that often that vulnerable parent feels better heard and able to participate in an out-of-court process. So what are these out-of-court processes? So what are these options that the separating couple must consider? So under Section 16.1, sub 6 of the Divorce Act, and this is all subject to provincial law, the court can include in a parenting order a requirement to participate in any of these processes: mediation, negotiation, collaborative law. Now we are going to take a look specifically at Saskatchewan because that's the jurisdiction that I practice out of, and we've had very recent changes to our provincial legislation to really put some meat behind what is intended here and encouraging families to try something that is not adversarial in nature. And I'm sure these terms are familiar to you, but let me just give you a very brief definition of each of these processes that the Divorce Act speaks to. So mediation is where there's a neutral third party who's really facilitating the conversation between the parents. This person is someone who helps the parties speak to what their individual priorities are, what their expectations are. It's an environment where assumptions can be tested to say, well, I'm assuming if we put this plan in place, this is what would happen. And so as the mediator, you can raise the open-ended questions to have them think about, well, how does this actually play out if we go down this path compared to a different path where we make this choice related to whether it's property division or parenting or support provisions that will be put in place. The mediator also asks the parties to think about, well, what are their concerns that they might have about trying something or implementing a parenting arrangement that looks in one way compared to a different way? What are some of their hopes? Like, what are their goals, their short-term goals and their long-term goals? And allows them to speak and identify all of these different interests that they have that are actually a reflection of their closely held beliefs, values, fears that they might have, and needs. And those needs can be super basic, like our Maslow hierarchy of needs. They just have the needs around food, shelter, security, clothing, and how as a parent, if they have security in those things being able to be part of the outcome, they're going to be in a better place to move up that next level to give the type of caring parenting attention that their children are going to need. So the mediator isn't there to advocate for either parent, is simply there to help them articulate those things that are important to them, so that when they are answering their questions about what it is that they're going to put in place and how they're going to move forward in this transition into a family system that looks different from what they're used to, they can then brainstorm, and they can brainstorm the options that are best suited to address those priorities and expectations and hopes and goals that they have. The mediator does not choose out of the list of options, instead allows the parties to evaluate them, the parents to say, hey, well, let's try this. The mediator can support them in trying something by saying, well, let's put a time frame, and then why don't you come back and meet with me again, and we can talk about how it's going and what can be tweaked and changed to make it better, and what are the things that are working well that might form your final agreement. Now, negotiation itself is something that parties, they can just literally sit across their kitchen table and have a discussion about all of those same things on their own to come up with an agreement. They don't necessarily have to work with a professional to negotiate, but often parents will each have a lawyer. And if a lawyer has specialized training in interest-based negotiation, they can be very helpful to the parties if they are only arguing from a place of legal rights and being adversarial, and even the fact that they're arguing, that is not necessarily a helpful negotiation, though that technically still represents negotiation. And the third process that's identified here is collaborative law, and that is a very specialized process that involves lawyers who have specialized training that are working together as a team, if you can imagine. So even though we are advocating for the interests and the things that are important to each of our respective clients, we're doing so in a way where we actually want to understand what is important to the other lawyer's client, so the other parent, because we know that if we can address those competing interests that they might have in a way that they both have peace about and is workable for them as a family system, then that's how we're best serving the best interests of our clients. That's how we are being the absolute best advocates for our clients. Collaborative law involves a participation agreement that both lawyers as well as the clients will sign that actually says we're taking court off the table. So it includes a disqualification clause that says if the parties aren't able to reach their own agreement between them, that then the lawyers that are involved have to withdraw. They can't be part of the legal process in the court system, and the family would start over again. And that is a way to protect them from having anything that might come up during that collaborative negotiation process be used against them in some way. We find that this is a really attractive process for other professionals that might get involved. So it's an interdisciplinary approach that we often will invite social workers into, or financial neutrals, or child psychologists to be able to provide their wisdom and guidance and help the parties identify what might be appropriate. And as soon as you are part of that process, you also are disqualified from being called as a witness into an adversarial setting. So this demonstrates the commitment not only on the part of the parents, but all the professionals that are involved, that commitment to reaching an agreement that's going to put the children's interest first, and one that will be, maybe not easy to get to, but is one that that's all they're aiming for. There's no game playing, there's no strategizing. It's really trying to literally build solid foundations for each home that the children are going to be living in and spending time in, and spending time with each parent going forward. Now, in Saskatchewan, what we have done is we have implemented something that's called mandatory early dispute resolution. We call that MEDAR for short. And it's really taking that Divorce Act premise that says, hey, you shall participate in some type of a family dispute resolution process. And we've articulated it in perhaps a little bit more detail here in Saskatchewan. And so I'd like to share that information with you to be able to just explain it. I realize that many of you aren't here from Saskatchewan, but just to explain what we're doing here so that you have a sense of where we're at in Saskatchewan. So our Queen's Bench Act at section 44.01 has been amended to include a definition of family dispute resolution. So you'll see the similar language here. This means a process that's used by parties that is, an attempt to try to resolve one or more of their disputed issues. And these processes include the services of the following persons. So a family mediator. So as I've described, this is somebody that is a neutral third party. And here in Saskatchewan, there are specific educational requirements in order to be identified as a family mediator for the purposes of this section. You could be a family arbitrator to provide services. You could be a parent coordinator and provide services. There are other the collaborative law services that I was just speaking to, as well as this kind of catch-all of any other process or service that might be prescribed in the regulations. And I'll just say that right now our regulations don't have any other processes or services prescribed, but it's left room for the development of perhaps we'll take in an Indigenous family perhaps that might say, well, we don't have a process in our community that we call mediation or that is collaborative law, and we want to, we don't want to seek the services of an arbitrator or a parent coordinator, but we do have an elder, or we have, we'd like to have a community circle, some sort of perhaps a healing ceremony. And so these kinds of processes that might still be in line with what is intended in the legislation as far as encouraging families to think about their dispute and the resolution of it in a non-adversarial way that may be specific to someone's culture or some pre-existing kind of a process that at the moment just hasn't been articulated in legislation. So our government has left room for that to develop. I will just quickly note that the family arbitrator and the parent coordinator, they are included in these process options. I'm not talking about those so much today because they are a slightly different thing in that they involve a third party coming in and actually making decisions for the family. So in the case of an arbitrator, it's different than our typical like in court adversarial process, but it's still one where the parents are saying, hey, look, we're kind of stuck. We don't know what to do. We're going to present our evidence to you as somebody who's qualified to tell us what to do, and then we will go and do what you've told us to do. And in the parent coordinator, it's sort of like a mix between being a mediator and an arbitrator, because the parent coordinator has the ability to encourage and to coach and empower the parents to try to sort out their problems with some assistance. But at the end of the day, if they can't figure it out, that parent coordinator can then put on their arbitrator hat and say, well, all right, this is what you're going to do, and let's carry on. Each of these types of professionals are specialty designations that you can get a training in, and each province will have different types of requirements in order to be able to practice in that area, in either of those areas, and also will define what you're actually allowed to make decisions on, and that varies from province to province. So in Saskatchewan, what exactly do the MEDAR provisions apply to? Any applications that are made pursuant to the Children's Law Act, the Family Maintenance Act, and the Family Property Act, and then, of course, the Divorce Act. The exception to this is that the Child and Family Services Act, that has some overlap to the Children's Law Act, the MEDAR provisions do not apply to those proceedings. The Child and Family Services Act is our legislation in Saskatchewan that is utilized in child protection matters, so the MEDAR provisions do not apply there. But otherwise, the Children's Law Act, that's all about parenting. It's all around figuring out, how do we make decisions for children? How do we make sure that their psychological and physical and emotional well-being, all of those needs are being met. The Family Maintenance Act is all about our support, our financial support obligations. The Family Property Act is how parents or spouses would be dividing their property when they are moving into separate and apart lives. Now, in Saskatchewan, at the end of what we call pleadings, so when somebody starts a court action, they must participate in one of these family dispute resolution processes, and then they file with the court a certificate of participation in one of those processes. Now, sometimes people will participate in a process without ever going to court. So the two things are not married, forgive the pun. They do not have to go hand in hand. It's simply that if you do want to go to court, if you want to continue with an application, well, before you could go beyond the basic step of the opening the file, which is what the pleadings are, then you must then show evidence of having participated in one of these processes. For people who maybe try a process before starting a court action, that can count if they've used an authorized and approved service provider and they have this certificate of participation to file. And I would say, as far as my practice is concerned, the majority of families that we work with out of my office, they have never started a court action, nor do they ever intend to. But there are also people that, you know that saying, you can lead a horse to water, but you can't make them drink. Well, there's a little bit here about this as well, right? There are going to always be some families that, for whatever reason, they just will not be able to extricate themselves from their conflict, and it will be necessary to them, and it's the only thing that they can think of is getting their day in court, right? And they want that experience. And I don't know that they actually want the experience as much as what they presume will be the outcome, and that's the only way they think that they're going to get that. So you're always going to have some of those people. You're always going to have some people that would just never, ever want to go to court. But what's really important about these new provisions is all of the people in the middle there. These are people that have maybe never even heard of processes like mediation and collaborative law, and it's never crossed their mind that they might be able to actually sit down with a professional and taking an interest-based approach and problem solving a creative solution and parenting arrangement for them as they've transitioned into a new family system set up. So currently in Saskatchewan, though our laws have changed, the mandatory nature of all of this is applicable only to one judicial center. It's the Judicial Center of Prince Albert. That's kind of a northern part of our province as the first step in the implementation. And of course, there were some plans that maybe have been interrupted slightly by this thing called a pandemic. Some of you may have heard about it. It's kind of unique to 2020 and about 100 years ago as well. And so we, some of the rollouts of the changes to the Divorce Act and the rollout of the implementation of our MEDAR provisions here in Saskatchewan have been a little bit delayed, but that's not changing the fact that this is the direction this is going in. Now, what about somebody who just doesn't want to? right? They're like, maybe they fall into that category of people that they're just stubborn and they're determined, or maybe it's less that and more that they have an avoidant type of personality, or perhaps they're somewhere in their grieving cycle where they're still experiencing an amygdala hijack and they just cannot imagine being in some kind of a problem solving process because their emotion is really just occupying them. So they say, you know what, forget it, I'm not going to do this. Well, we do have some provisions in our legislation. So if somebody fails to participate, they're then prohibited from going further in the proceedings, and they can't file anything further with the court in terms of an application for relief. So this is not a suggestion. This is something that has been designed with teeth, with meat on its bones, to say we are serious about trying to create a new way for families to sort out their differences and come up with an action plan that's going to be best for their children. And it's not new in the sense that things like mediation, or you maybe have, you don't use that label, but where there have been peacemakers that sit down and try to help people sort things out. I mean, that's been around since the dawn of time, but it's all about changing the paradigm, the way that we think about family separation and divorce. First of all, this is not an anomaly. If we're looking at statistics that say, give or take 50% of long-term relationships at some point have an expiration date, and then they move into a new, either a different spousal relationship with somebody that they care about, or that particular spousal relationship needs to change its format. This is not news. This isn't something that's, we should be surprised by, that this happens. It's been happening for as long as there have been peacemakers, where there are people that have conflict and they need some assistance. So our paradigm, though, is that when people are in conflict, when families are in conflict, somehow the law needs to step in, and it needs to step in an adversarial format and say, oh, you know what, you were bad, and or this is the outcome that in the consequences, and good luck, now carry on. But that we have advanced now, and we understand that that is just not a reflection of people's experience in life, that they need to approach these things differently. So there are other consequences. And not only are you not going to be allowed to continue, potentially, if you really are very avoidant on this, the court can strike out what's called your pleadings or your other documents and just say, well, you know what, we're not even going to consider your position then. The court could refuse to allow the party to make submissions, could actually order the party to participate, which, side note, I didn't draft this legislation, and I'm not being disrespectful when I'm just like, I think this is interesting. It's already a requirement, and the consequence for not participating is that, well, then we're going to order you to. So it's almost like when I, have perhaps a child in my house that had selective hearing and didn't listen to me the first time, I'll say, no, I really meant it. So here, now I'm ordering you. And of course, the court also has discretion to order costs or some other type of relief. Now, this is kind of punitive, and it's not in line with really the overall intention here to encourage people to approach things differently and through an interest-based perspective. But if somebody doesn't believe that the court and the legislation actually means what they're saying, then here's where the teeth are, and that it is in these other consequences. So some of the features here is that, this is voluntary in most cases, right? Mediation and collaborative process. And there's these new mandatory provisions that say, well, you have to at least try this, and we can lead the horse to water. We can't make them drink, but what we can do is we can give them an experience, right? We can say, here's an environment where somebody's going to actually help facilitate you being able to speak to not your legal rights, but instead the things that are important to you, the things that matter to you, that are a reflection of your closely held values and beliefs, and thinking about what it is that you want. Like, what do you want your child or your children, their future selves, to be able to tell about their experience of growing up in a separated household? What story do you want that to be? And so you might not voluntarily be participating in the process because it's been mandated or because you didn't want to separate in the first place, but you can bring in that mindset of voluntariness. It's an interest-based type of a process. So it's the reason why a particular outcome is important, whereas in that adversarial process, people are focusing on the positions, which basically, is usually a reflection of what they think should be the outcome. And we often, present in training this iceberg as a visual to support this, is that what we see on the top in conflict are people's positions. They say, well, I want to have primary parenting, which even as a phrase is such a bizarre thing to say. Somehow you're elevating one parent over the other parent to be the primary. There are lots of semantics in family law that I'm so excited to see being tossed out with the changes to the Divorce Act. You'll note that the word custody is no longer going to be used. It will take a long time for that to remove itself from our processes that are in place because it's been around for so long. But if you think about what custody means, custody is all about ownership and control, whereas really what we're talking about in custody, what the legal meaning of that is, the decision making. And so if you are going to engage in joint decision making for your children, this is a very different way of approaching it than somehow having that tug of war around, well, I should have ownership of that child and the custody. So changing that language. Even you'll notice that the word access is being removed. So parents will no longer get to access their children. Isn't that clever? They will be able to actually have time with their children, because that is what we are doing when we're helping them figure out their new parenting arrangement. This is an arrangement. This is how are they going to effectively work together and provide for their child's needs. This is not about ownership or having these windows of time where you just get to access. So we're changing some of the language so we can move it from being this positional thought process to understanding what those underlying interests and needs are for each member of the family and the family as a collective. These processes are goal-oriented, the focus being on the future instead of what did or did not happen in the past. So it's not about collecting evidence and trying to rehash what are arguably going to be not consistent memories or perhaps accurate memories of what has happened in the past, but we're thinking about what is it that the family is going to need, what do the children need, what are the visions and the goals for the future. It's to be mutually beneficial in both mediation as well as collaborative law. An agreement is only finalized when both parents are satisfied with the outcome, and the parents are able to retain ownership over that outcome. So rather than somebody else saying, well, guess what, this is what it is that you're going to do, they can look at what it is that they've engaged in creating as a plan and say, hey, I participated in the creation of this. Social science research tells us people tend to adhere to and follow through on agreements that they've been involved in creating at a much higher percentage rate and more consistently than they do when something's been imposed upon them. Family dispute resolution processes fundamentally work for families because people who are in conflict are the ones who know their situation the most intimately. And ultimately, they know what is going to be the best outcome for themselves and their family. Sometimes they need some help in figuring that out and understanding what the options are. And that's where all of the professionals that circle around and provide support to families can bring to their negotiations by using some type of a process like mediation or collaborative law that is actually just saying, hey, this isn't a game. This isn't about pitting us against each other, trying to bring out the worst, trying to keep track of all of the missteps along the way. It's about putting a focus on what is going to be best. So what does this mean for you as a collective of social workers? Well, I hope that in today's webinar and any follow-up discussions that we might have, either still in these last few minutes we have together today, or if we connect offline, is that you will be able to talk to the people that you work with in a way that helps them understand that there is a better way. There are these options, and in fact, there is now this change that's going to make this not only important but necessary to try to engage in interest-based processes. And you're on the front line, right? You're talking to people. You'll be able to say, hey, even if you don't know intimately the details of how the processes would work, but you say, hey, I know there's mediation, there's collaborative law. In fact, you can go right outside of the adversarial system and engage the services of other people like parent coordinators or arbitrators to be able to help you work through things to create this foundation, this healthy foundation, this effective foundation going forward, which is only going to be super awesome and excellent for your children. And you are going to be able to share that education. You're going to be able to help to impact the culture, the understanding of what's all possible. And so that's what this means for you. And I hope that's part of the reason why you came today, so that you could learn a little bit more, so you could tell others. But I also hope that for those of you who might be interested in learning how to be a service provider, whether it's in a collaborative context or as a mediator, that you know that this is an opportunity to expand your skill set and diversify. And if this is something that you have more questions about that you would like to explore, please feel free to contact me. We have an academy here out of Saskatchewan, but it's all virtually. All the courses are offered virtually. It's the Common Sense Mediation Academy, and you can visit our website and also send us an email at your convenience. Like I said before, we're only an email or phone call away. So we want to leave the last 10 minutes-ish for questions. And so I hope that Karen and Ruth Ann have had a chance to kind of monitor any questions that you've been posting. And I'd just like to have a bit of a conversation here in our last few minutes.
Great. Thank you so much, Charmaine. Yes, we have a couple questions, and we might have room for a couple more if anyone wants to send any in. I am going to start. First of all, I do want to make a comment, though, and I think one of the things that you mentioned was the importance of language and how language is changing, from access, custody. Changing the language is so important, and it does change kind of the tone and the expectations. So I really appreciate your getting us to think about language, and that's really important. One of the questions ties into a question that I had, so I'm going to try and put them together. At the very beginning, you mentioned Section 7.3 of the Divorce Act, which says to the extent appropriate, and there was the word appropriate. And I was wondering kind of what that meant, but one of the questions that we have is that what would happen if one of the parties starts to become abusive and it's not possible to kind of move through a process, one of the processes that you've outlined. How would that be handled? or how might it be flagged, or what might be alternatives, or does it go back to court?
Well, it kind of depends on the situation, which is always my go-to answer, as Ruthann will be able to tell you, is that every situation is so different, of course. However, within the Divorce Act, that reference to, if it's appropriate to do so, and that's reflected as well in our Saskatchewan legislation, it is in recognition of the fact that there will be certain circumstances. Like, for example, if a parent has kidnapped a child to another country, it's going to be very difficult to force a family dispute resolution process that's interest-based. You just maybe don't even know where they are. And where there's evidence of abuse, and it's abuse that is such that the victim says, I just could not participate in some type of a process like this, then that could be an occasion where they would be exempted. But it's not going to be an automatic exemption, because there are a couple things to keep in mind. One is, first of all, that the person who is the victim in the situation, we want to empower them, because we know that participating in the court system can be just as difficult and can compound that abuse in many instances. And this is where maybe we're talking more coercive control or other kinds of abuse, maybe not the physical abuse, but the fact that we now have the ability to facilitate dispute resolution processes online, where you can minimize some of the risk that could be present by physically requiring people together. There are all sorts of process design that is possible. So before ruling that out for somebody who's coming out of a relationship with elements of domestic violence, is to actually speak to the victim to say, so what are some of the things that are important to you? Is there a way we can design this process with safety in mind in order to make this workable for you? And as you go along in your process, if there was ever a time where somebody wasn't participating in good faith, or they were somehow manipulating or trying to utilize the process in a way that was causing harm, as a service provider, you need to have that specialized training to be aware of and observe those flags, so that you can either release them back to court if they wish, or you can tweak your system, your process, or bring in other professionals rather than just to send them off and somehow keep your fingers crossed that they're going to find some better pathway. I would suggest it. Ethically, it's important to us, it's incumbent on us as service providers to not only be aware of these things, but to be proactive in helping families figure out what tools are available to them to help them when they have those kinds of challenges.
Good, thank you. Another question, as social workers, how do we direct parents? Where do we direct parents, either in terms of phone numbers or websites, in order to start the process? So as a social worker, how would we, get our people that we're working with involved in the process, if that was appropriate?
I would say start by connecting them with organizations. So every province across Canada both has an ADR Institute, provincial affiliate. So the ADR Institute of Canada is the national organization that provides designations to mediators, and each provincial affiliate will have their membership is posted on their website. Depending on where your individual province is at in implementing some of these new ways of doing things, I can tell you here in Saskatchewan, our government also posts a list of family mediators. So by having that designation, you are somebody that the government recognizes as having the necessary qualifications and experience to provide the MEDAR services. There's also the collaborative professionals associations throughout the country, and each province will have an association that has not only collaboratively trained lawyers, but other professionals that are collaboratively trained to support that process for the lawyers as well as the clients that are involved. So as a social worker, I would say to start by familiarizing yourself with some of those organizations. Actually, have lunch with some people that are on those rosters, right? Or coffee or telephone conversations, because just because somebody holds a designation or has had particular kinds of training doesn't necessarily mean that their philosophy of practice aligns with the things that are important to you as a social worker. So rather than just blindly sending your clients off to try to find who's going to be a good fit, it was probably really helpful for you to get to know some of those service providers, and then you have some particular people that you can refer to as well.
Right, good. Okay, that's great. Another question, are these processes are going to be implemented in all provinces at some point? Is that the intent?
So,
Yeah.
yeah. So under the Divorce Act, because it says, hey, look, you have to participate in a mediation or in a negotiation or collaborative law. Arguably, all lawyers across Canada will say, well, I will support my client in engaging in a negotiation. Now, there isn't a further definition of what kind of negotiation. So not every negotiation is interest-based, but the requirement at that level is to say you have to have tried something. Now, provincially, each province will have different provincial requirements under their Queen's Bench rules. And in Saskatchewan, ours further expands that to say, well, it has to be one of these particular processes. It can't just be negotiation where the lawyers say, yes, well, we participated in some type of negotiation. It actually has to be one of these defined processes. So what each province will do on their own, the Divorce Act itself, when these changes come into play, will apply across the board. But whether the service providers will be as perhaps regulated isn't quite the right word, but will have as much guidance from each provincial government is still to be told. We'll have to wait to see.
Yeah, good. Okay, one more quick question, and it's a bit perhaps more of a technical question, but what is the age that a child can decide if they want to visit another parent, or what's that age where a child gets to make some decisions?
This is a great question. It comes up very often. So it depends what province that you're in. In Saskatchewan, I can tell you it's age 18. That is the age of majority. And that comes as a surprise to most people because there is this sort of urban legend out there that says, well, when children are 12, they can decide what they're going to want to do. Well, that is actually not true. But in practical sense, as children get older, and sometimes that can be as young as, like little children can be very what's the word I'm looking for? Like really very articulate as to what they want, right? But the older a child is, the more difficult it is to sort of force your own adult agenda on them to say, you have to go and spend time with that other parent, or you have to spend this time with me. So from a practical point of view, as they get older, it becomes more difficult. But from a legal point of view, it's the age of majority. They are minors until they are adults.
Okay. Good. Well, we're out of time. We're a little bit over. So, Charlene, thank you so much for sharing your expertise with us today in such an engaging manner. It's been a great presentation and given us lots to think about. And for everyone who joined us, thank you so much for being with us today. And everyone, stay safe and take care.
Thank you.